Mr. Mendelis, you can proceed.
Thank you. I think the mayor is going to open the meeting.
Thank you, Max. It is Tuesday, November 9th, 2021. This is a virtual special meeting of the Commissioners of Rehoboth Beach, Planning and Shade Tree Commission, Board of Commissioners, Board of Adjustment, and Planning Commission. Thank you all for being here. This is a special meeting for the purpose of conducting FOIA and Ethics training. As such, because it's a training session, I'm not going to call roll call. The target audience for this FOIA session is the Planning, Parks and Shade Tree Commission, Board of Commissioners, Board of Adjustment, and Planning Commission. Later, we will target the lesser committees, if you will. Sorry for short notice on this. We had an opportunity and we thought we would fill it and get this squeezed in. So I appreciate that everybody is able to attend today virtually. And also, this will be is being recorded and will be made available to watch at a later date and archived. And so the non-attendees to this meeting today will be requested to watch the video, and if they have any questions, to confer with Glenn directly. This is a very, very important topic, and that's why we are recording it and archiving it, because essentially, the transparency of our city government is at stake. With that, we'll go turn it over to Glenn. Glenn suggested that if you have questions at the time, raise your hand the best you can, and I'll look for you. If I overlook you, please speak up. It's probably best to ask the questions when a slide is up rather than 10 slides later. Thank you very much. Appreciate you being here. I'm going to turn it over to Mr. Mendelis.
Thank you, Mr. Mayor, and thank you, everybody, for being here. It is a beautiful Tuesday morning moving into the afternoon, and so we'll try to make this as quick as we can. I do intend for today's training to be predominantly sort of the high-level stuff, the basics. Sometimes remembering the basics is the most important part of getting this stuff right. And as elected and appointed officials, it's important that we do get it right and pay attention to obligations under the Freedom of Information Act and under the State Code of Conduct. So those are primarily the two areas we're going to be talking about today, Freedom of Information Act and the Code of Ethics. So Max, I'm going to go ahead and share my screen if I may.
Absolutely.
So, and as the mayor said, feel free to interrupt me. Sometimes it's best to get the questions on the table as we're going. I'd rather this be kind of interactive and get questions answered that are important to you than overlook them and have you forget about them at the end or something. So we're here today to talk about Freedom of Information Act beginning first. So the Freedom of Information Act is Delaware's open meeting law. It's contained within Title 29 of the Delaware Code at Section 10,004. It predominantly deals with two basic components, those being open meetings and open records. That sounds pretty simple, but as you'll see, those two areas can get us into some tricky areas. Ann Womack, who's the city's FOIA coordinator, can certainly tell you some more stories, and the mayor and I were joking before this training started. He's got some more stories along the way as well about how to comply properly with FOIA in both open meetings and open records. So the policy is that it's vital in a democratic society that public business be performed in an open and public manner so that our citizens shall have the opportunity to observe the performance of public officials and monitor the decisions that are made. So that's really what FOIA is all about, allowing the public to have access and observe those people who are entrusted to be making decisions on behalf of the public. So it's all about public access. So what is a public body? A public body is what's subject to this Freedom of Information Act, and a public body includes any regulatory, administrative, advisory, executive, appointive, or legislative body of any political subdivision of the state. And the reason I wanted to read that out loud, and I'm going to read the next bullet as well, is because the definition of a public body is extremely expansive. Everybody on this call that I could see in the Zoom session is is a member of a public body. Clearly, the Board of Adjustment, the Board of Commissioners, the Parks and Shade Tree Commission, the Planning Commission, they're all public bodies. But it gets deeper than that when you're talking about access of the public to its government. It gets deeper as to what makes up a public body. So bullet number 2 gives us a little bit more of a flavor. It says that means any board, bureau, commission, and by the way, this is a quote out of the statute. Any board, bureau, commission, department, agency, committee, ad hoc committee, special committee, temporary committee, advisory board and committee, subcommittee, legislative committee, association, group, panel, council, or any other entity or body is subject to FOIA. So it's extremely expansive. So I get concerned sometimes when I have a public body that I'm sitting with, and for example, the chairperson will say, hey, Jim and Rick, why don't the two of you take a look at this and come back and report to us? When that happens, a public body has been created. And when a public body has been created, they're subject to all the rigors of FOIA. That is, they have to have public meetings, they have to notice those public meetings, they have to take minutes during those public meetings, and they have to have access. The public has to have access so they can observe all of those public meetings. So it can be very, very innocent, but it's extremely easy to create a public body that is subject to FOIA. And so if there's a quorum of members present conducting business, there's a meeting of the public body. So what does that mean? If there are 5 people on the body, like the Board of Adjustment, for example, a quorum of members in the city, we have a basic statute that says a majority makes a quorum unless there's some other provision saying otherwise. So almost all of our public bodies, I can't think of any of them, Mayor, and jump in if you can, but I think all of them within the city, it's a majority constitutes a quorum. So on the Board of Adjustment, for example, 3 members make up a quorum. So if 3 members get together and they want to discuss an application that's going to come before them, that constitutes a meeting of the public body, and it needs to be subjected to all the rigors of FOIA, including notice to the public, minutes, all of those things. Now go back to the scenario we were talking about where the chairperson says, hey, Jim and Rick, I'd like you to take a look at this. Now you've got 2 members of the public body. So the 2 of them, if they get together, same thing. All the rigors of FOIA apply. So public meetings, what is a public meeting? A meeting for purposes of FOIA means the formal or informal gathering of a quorum for the purpose of discussing or taking action on public business. So we talked about what a quorum is. What is discussing or taking action on public business? Well, for example, as we just discussed in the Board of Adjustment, if 3 members or 5 members want to get together to discuss an application that's coming before them, that's public business. You're conducting business that is the business of the public. If those same 3 members wanted to get together and watch the Steelers and the Bears game that happened last night, no problem whatsoever. They can get together, they can watch the game, they can talk about the game, they can talk about what they had for lunch, they can talk about the golf game that was on earlier. All of those things are fine because they're not conducting public business. But when, during a break in the game, one member of those 3 members, which constitute a quorum, one of those members say, hey, next Friday's meeting is coming up and we've got this application, here's what I think. And the other member says, well, really? Well, here's what I think. Well, now you're conducting public business. There's a quorum present, and it needs to be properly noticed, and the public should have access to that meeting. So any questions on what a public meeting is, what a quorum is, just kind of that basic concept, because that's where it all starts, and that's where we see the most problems occurring. Many of the problems that occur in FOIA are members getting together, and we're going to talk about some other scenarios on how you can very innocently get into trouble with the public meetings and quorums.
Glenn, I'd just like to insert some examples from my 14 years or whatever I've been here, observations. And this is very important, public bodies and when they meet. There have been, even within town and outside of town, groups that have gotten together with a minimum quorum. and they'd start talking business, and then they reveal it to the public at the next meeting. They said, remember we discussed that when we met at so-and-so's bar. So obviously you can't say that, but it doesn't mean hide it. It means just please don't do it.
Right. That's exactly right. 'Cause it's embarrassing for the public body when it's revealed in a public meeting that in violation of FOIA, a meeting occurred outside of the public's view. Now, the flip side of that we all need to remember too is just because you're a member of a public body, it doesn't mean that you can never then discuss public business with another member of that public body outside of the public. So, for example, we saw a moment ago that there has to be a quorum present. So if you're on a body, say it's a 5-member body and 3 is a quorum, if 2 members want to get together to discuss an application or some thoughts on an application, that's actually completely legal and fine under FOIA. You can do that. But we're going to see later how that can become problematic if one of those 2 members then goes to a 3rd member and says, hey, Rick and Jim and I discussed this. Let me tell you what we think. What do you think? Now you've got 3 members, even though they weren't all present in the same location, you've got 3 members who have discussed public business outside of the public's view. It was a quorum of members, and that's a violation of FOIA. It's called a serial meeting. I'm getting a little bit ahead of myself, but that's when you can run into trouble. But I want you all to be aware that FOIA doesn't create an absolute prohibition on members of a public body discussing public business with another member or 2 members, so long as it's less than a quorum having the discussion. But the general rule, subject to few exceptions, is that every meeting of all public bodies shall be open to the public. So if there's doubt, the discussion in the meeting should be in the public and follow the statute. And just to be clear, meetings have to be held within the jurisdiction of the public body. Because of the pandemic, FOIA has been expanded somewhat, and we can do virtual meetings, but as you know, there still has to be an anchor location. I'll talk more about that in a moment. FOIA does not prohibit members of a public body from participating in other groups or attending other functions, so long as those gatherings do not discuss as a quorum the public business of the public body, which they are members. And that was what I was just discussing with, for example, going to a football game together, or doing something outside of your role as a member of the public body. So here's the slide on serial meetings. So I was just talking about how 2 members of a body that has a 3-member quorum, 2 members can get together and discuss it. If they discuss then what they talked about with a 3rd member, then you get into trouble. But the place that we really see this most often is in emails. So you'll have one member email another member and say, you know, we've had this coming before us. Here are my thoughts. What are yours? And the other member responds. And again, there's absolutely no problem with that. But then if one of those members forwards that email discussion to a 3rd member and says, see below, and again, we're talking about a public body where 3 members constitutes a quorum. So if 2 people talk by email, they forward it to a 3rd person and say, here's our thoughts, what do you think? That constitutes a serial meeting. Now you're discussing public business with a quorum of members outside of the public view. It's a violation of FOIA. So you have to be really careful with it. It happens also with telephone calls. 2 people talk on the phone, then one of those 2 people calls up a 3rd member of the public body, and that as well constitutes a public meeting. So we think in terms of meetings being everybody co-located in one area talking together, but they can happen serially over time, and you have to be very cognizant of that possibility, and because that is one of the areas that is the most difficult to navigate. It used to be under FOIA that if you were on an elected body, you could not participate by video conference, and teleconferencing was completely prohibited. FOIA, like I said, has been expanded due to the pandemic, and now there is an allowance for the type of meeting we're having right now, which is a virtual meeting. And in a virtual meeting, you have an anchor location where one member of the public body has to be present in a room where the public can come and attend if they desire. Today, Mayor Mills is here holding down the anchor location, so we have a properly noticed and we're properly conducting this virtual meeting.
Glenn, can I make a comment on serial meetings there?
Yes.
Because it's something I do, and I want to make sure that everybody's aware of it and the propriety of it, if you could comment on it. A lot of times our constituents write to all the commissioners. So they'll write a question to the entirety of the commission. And I'd like to give an example of how I have responded in the past and the dangers of replying all, if you will. And that is a specific question about something about the boardwalk design. Why didn't we do this, or why didn't we do that? And I have taken the opportunity, since I know the answer, to hit reply all, which means I'm replying to the constituent that's asked the question, but I'm also replying to all the commissioners at the same time. And why I do that, and I do it very, very judiciously, but why I do that is because I know the answer. And likely all the other commissioners do not. And so it's done out of, in part, to be courteous and respond to the constituent, but also to educate the commissioners. And what I do at the bottom, and again, this has to be used very judiciously, but at the bottom of my email, I make a note that says, this response is not intended to solicit a group response, meaning I do not want any other commissioners to respond to my email. If you then choose to respond individually to that constituent, that's all right. But trying to avoid that serial email situation. We're okay there, aren't we?
Absolutely, and that's a good practice to get into. Is if for some reason there is a quorum on a let me step back. So passive communications, I want to talk about for a moment, are okay. So for example, if a chairperson of a board or commission or committee wants to send out materials in advance of a meeting, that chairperson can send it to the entire public body and say, here are some materials I think you should have in advance of the meeting. Please review. We'll discuss them at the meeting. That kind of a communication, even though there's more than a quorum or a quorum or more on the email, is completely fine. It doesn't become a problem until somebody hits reply all or replies to a quorum of members and says, I've reviewed the materials, here's what I think. Now, again, you're conducting a meeting outside of public business. But the mayor's point is a good one in that to the extent you're going to have an email that does have a quorum or more members on it, and it's conducted properly, that is a passive email, it's always a good idea to put some sort of an indication on it to alert folks that there is a quorum on the email and that they should not reply all so as to avoid a FOIA violation. So I typically will write at the top of the email, please do not reply all to avoid a FOIA violation. So something like that, just to alert everybody that you're in this kind of, you're on thin ice. It's completely legal at this point, but one more email going back to everybody that starts to discuss the public business would become a violation. So it's a good idea just to try to alert people to that possibility. This is a slide that sometimes people have questions about and they can be bothered by. FOIA is interesting in that we saw the public policy reason for FOIA. That is, FOIA exists to allow the public to observe its elected and appointed officials as they conduct public business, as they make decisions that will affect the community. But I want to read from a case called Ritter versus Department of Insurance. It says, although FOIA entitles citizens to notice of public meetings and to attend meetings of public bodies, FOIA does not mandate that public bodies allow for public comments at any or all meetings. There is nothing in the text of the Declaration of Policy or the open meeting provision requiring public comment or guaranteeing the public the right to participate by questioning or commenting during meetings. What is provided by FOIA generally, and by the open meeting provision in particular, is public access to attend and listen to meetings. So we do a pretty good job, I think, in Rehoboth Beach of allowing the public to comment on, virtually every agenda topic that comes up in our meetings. There's an opportunity for public comment. But that is at the discretion of the chairperson and the public body and largely a policy set out by the city. It's not required by FOIA that members of the public be able to actually participate in the meetings. Now, as this slide demonstrates, a public meeting is different from a public hearing. So a public meeting, which is what FOIA requires, that our meetings be open to the public and the public be able to observe government in action, that's different from a public hearing. So there are some state code requirements that require a public body to conduct a public hearing. That's an instance where the public body is required to listen to the public and required to take public comment and required to consider what the public says in making its decisions. So that is typically in things like zoning code amendments, subdivision approvals. But again, a public hearing is something that is created outside of the Freedom of Information Act. Freedom of Information Act is only exists to provide access by the public to the public body to be able to observe what the public body is doing. A public hearing is kind of a different animal in that it's a requirement that the public body take public comment. Meeting minutes. During every public meeting, there's a requirement under the act that minutes be taken. Ann Womack, who does a yeoman's job of keeping minutes for our boards and commissions, I must say she goes way above and beyond what FOIA actually requires. So FOIA requires the minutes to include a record of those members present and a record by individual members of each vote taken and the action agreed upon. And that's all it requires. So, for example, the city's talking right now about different refuse decisions and when collection time should be. And there's been several meetings discussing that material. But all Ann really needs to put into the minutes are the members were present, they talked about pickup time, and a vote here. There was a motion made by this person, it was seconded by that person, and here's how the vote went. Ann does a very good job, I think, of creating a very relevant historical record, so we can go back and look at the legislative history as to why decisions were made, the way they were made, what commissioners said at the time. But that is way above and beyond what is actually required by the act for the meeting minutes. Let's talk for a moment about executive sessions. So executive sessions are the exception to the rule. That is, when can the public body meet legally and not do it in an open public meeting? And what the cases say that any exception to the open meeting requirements are to be construed narrowly. Open meeting laws are liberally construed, and closed session exceptions within these statutes are strictly interpreted to limit non-public meetings. So basically, meeting outside of the public should be the exception to the rule and should not occur often. And there are only a few exceptions that allow a public body to meet outside of the public. And here are some of them. Litigation and collective bargaining strategy sessions. So, for example, our police department is unionized, and there's negotiations that go on for the police contract every several years. Those information about those sessions can be done in an executive session. So, for example, the commissioners want to know the status of the negotiations on the police contract. The commissioners can meet in an executive session to talk about it. Of course, that makes sense because when you're negotiating a labor employment contract, you don't want the other side to sort of know your strategy and where you're willing to give and where you're not willing to give. Same thing for litigation. There's a litigation exception because you don't want your adversary to know what your strengths and weaknesses of your case are. So you can meet in an executive session for those reasons. Preliminary discussion on the sale, purchase, or lease of real estate, because you don't want the other side to know what price you might be willing to pay. Discussions which could disclose the identity of a charitable donor who wishes to remain anonymous. Look, if somebody wants to donate a large amount of money to the city, we're happy to do that confidentially and talk about it in an executive session. Then there's some personnel matters, including employee discipline and the qualifications of most job applicants and employees. But again, the executive sessions are the exception to the law. You should not be meeting in executive session very often unless it neatly fits into one of these exceptions. I want to talk for a moment about the litigation exception because it seems that anytime a topic feels uncomfortable to talk about in open session. Somebody will say, well, this is potential litigation. Somebody could file a lawsuit. What the cases say is that to invoke the potential litigation exception, litigation must be likely or reasonably foreseeable. And when you determine that, the public body should look for objective signs that the litigation is coming. For example, a written demand letter in which a claim is asserted or action is demanded may give rise to a proper inference that litigation will soon follow. So if we're considering a subdivision application, for example, and the neighbors don't like it, and we get a letter from an attorney representing the neighbors that says, you better not approve this subdivision or else we will file an action in state court, that's enough. That's enough for foreseeable litigation that would allow the public body to discuss its risks in the executive session. But it has to be something at that level. It can't just be simply, I've heard the neighbors don't like this, maybe it could lead to litigation. That's not enough to put you in a litigation scenario that would allow for an executive session. Other indicators of potential litigation might include previous or pre-existing litigation between the parties. So if these two parties have, if this party has sued the city previously on a similar claim, that may be enough. Proof of ongoing litigation concerning similar claims, proof that a party has both retained counsel with respect to the claims at issue and has expressed an intent to sue. The public body must be able to point to a realistic and tangible threat of litigation. So that's really the test. Is there a realistic and tangible threat of litigation? If so, then the litigation exception is available for the public body to meet outside of the public. So that's it pretty much for public meetings, open meetings. Before I move on to public records, which are the documents that have to be made available to the public, are there questions on public meetings?
Glenn, I'd like to make two comments real quick. One is on the executive session, and that is just a reminder that everything that happens in executive session is of a confidential nature. So you can't blurt out what happened in that executive session. The other thing is just more of a note to chairs about the reference to not having to let the public talk. Of course, we almost always allow the public to talk. But we'll let you know that if, for instance, you did have an opportunity where you decided that the public could not talk during your meeting, but you let somebody blurt out something and then you acquiesce and let them finish their statement, you now have to allow every member of the public the same opportunity to talk. So you've got to be a strong chair. If there's no opportunity to talk, then you need to adhere to that. It's just kind of a little nuance of some of the minutia of freedom of information. Thank you very much. Are there any questions up to this point?
I have a question.
Who's talking?
This is Tim Bennett, Commissioner Bennett.
Commissioner Bennett, go ahead.
I don't, this is just simply, for instance, with the Planning Commission, they're very busy working on the CDP currently. And how is that handled? Because my guess is they're probably working in small groups, big groups, sharing information with one another. Is that considered? What kind of meeting is that considered? Because my guess is they'd have to work as a group and probably also work as small groups, and they'd have to all talk to one another.
So I don't know if Mike Bryan is on and wants to talk a little bit about how we're conducting this, but we've been very careful not to do anything that creates a subcommittee. As I understand it, the Planning Commission right now, each individual is kind of acting autonomously and providing comments on the CDP back to the consultant, who then tries to incorporate all of the comments. So there's no, to my knowledge, there are no small groups that have been created, and there's not 2 or 3 people working together on Chapter 3 and 2 or 3 working together on Chapter 6. As I understand it, they're all acting individually right now, which does not create any subcommittees that would be subject to FOIA. Is Mike on, and does he want to comment?
I don't see him on today.
Okay. But the Planning Commission, you're right. It's a 9-member body, so you could have 3 or 4 members could be talking about things individually or collectively, and those 3 or 4 and still not constitute a quorum. So it would not be a violation of the Freedom of Information Act. However, if Chairperson Bryan said to 3 or 4 of them, I'd like you to work on Chapter 3 and report back to the Planning Commission your thoughts, at that point it does become a subcommittee and it is subject to the Freedom of Information Act. Does that make sense?
I would think that would be important. I mean, I'm not trying to cause any waves, but I just think as a group, those folks collective as a group, it would be important to have consensus or conversation back and forth. So that's why I think sometimes this to me, as I look at it, sometimes can be problematic because you want to have the best outcome for everybody. So if that requires the best minds of everybody working together collectively, this to me seems a little bit stringent in this case, and maybe this is an outlier with the CDP, but that was my question as to how is that handled?
Well, I appreciate you making that comment because I should say that FOIA is not easy. And so for example, a public body generally has to give 7 days notice of their public meetings. They have to say 7 days in advance, here's what we're going to talk about. Who lives their lives in 7-day increments, right? Who is able to say 7 days from now, this is what I'm going to do, and I have to put it on an agenda right now, and I can't deviate from that agenda. So right out of the box, government is going to be hindered in moving as aggressively as sometimes it would like to be able to, for good reason, to react to real concerns. But generally, government works on these 7-day intervals, and I think it is difficult. And I do think it's difficult for a public body to collaborate sometimes in ways that are efficient because of these laws. So, I mean, I think it's an interesting dynamic between the right of the public to observe its officials, which I think is extremely important because, let's be honest, somebody has to kind of be keeping an eye on how things are conducted on behalf of the public. So I think there's a great need, and the Act itself has really important objectives, but don't make any mistake about it. It does make the conducting of business more difficult for the public body, no doubt about it.
Thank you.
Mr.
Anything
Mayor?
else? Anything else, Tim?
No, thank you.
Thank you very much. We'll go
Mr.
to
Mayor?
Commissioner Chernowski and then Steve Kaufman. Commissioner Chernowski?
Thanks, Mayor. I just thought it was, we were talking about executive session, and I think it's just important to point out that we may discuss things in executive session, but we never take any action in executive session. So I think that's just a relevant point to make sure everyone understands.
Appreciate that. That is a good point. The Act prohibits any actual actions being taken during the executive session. So the public body can have discussions in executive session, but if it wants to take any action, it's required to come out of the executive session back into a public forum. Then a member would make a motion, get a second, and the public body would vote on the item in the public view. Thanks for adding that.
That's an excellent point, and I'd like to further clarify that what does it mean by action? Largely referring to a vote. So not even a straw vote is allowed. You can't seek consensus in the executive session. All you can do is talk about it. You can try to infer from those in there what they're thinking, but you're not really supposed to say it out loud. Anything else, Commissioner Chernowski?
That's it from me. Thanks.
All right, thank you. Well, we'll go to Steve Kaufman and then Laura Ritter. Steve, go ahead.
Thank you, Mayor. To answer the commissioner's question, Glenn is correct. We have not participated in any kind of group. We've done our individual comments and submitted them through the chair back to the consultant. In the future, we will have joint public meetings to discuss the next iteration of the consultant's draft of the comprehensive development plan. Up to this point, there's only been individual comment given to the consultants based upon the original draft they gave to us.
Thank you. Thank you. Before I go to Laura, I'd like to just take a quick lesson here for those that haven't used this type of Zoom meeting before. If you scroll to the bottom of your page, there should be a bar that comes up that includes the word participants. If you click on participants, then there's the opportunity to see the list of everybody that is attending today's meeting, and you have the opportunity to raise your hand, if you will, by clicking on it. So play around with that. That's how I am able to see some people who are raising their hands, and if those that aren't, just physically raise your hand and speak up. It'll come onto the screen. So next we'll go to Laura Ritter. You might be muted. Unmute yourself.
Hi, everybody. Good to see everybody it's been a long time. I just like to say one of the things that comes into conflict a lot with public records is, like when Glenn said, if people casually get together, not meaning to discuss public business, and no minutes are taken, nobody knows what is discussed during that meeting. So if you're meeting somewhere and somebody finds out about it, the public is going to assume that public issues were discussed. They're not going to assume that 3 people on a committee got together and never discussed anything public. They're going to assume, well, yeah, they talked about it. Of course they talked about it. So I think that is one of the big sources of conflict between the public and the public bodies. And it's just better if you're going to meet with people that constitute a forum, that it not happen in a private way, because it just gives the appearance of people discussing things, and it's problematic. That the public is going to call you out on it, whether you actually discuss public issues or not. So I just wanted to bring that.
I agree, Laura, and the public should call a public body out on it, right? That's the reason for the act. It exists so that the public can observe the public body in action. I've been in meetings not in this jurisdiction. Rehoboth, I will say that Rehoboth, I think, does a very good job of trying to keep their conversations in the public forum. But I have been in other jurisdictions sitting in the audience where an agenda item will come up, sometimes a complex agenda item where you would think there's going to be a fair amount of discussion about it, and then say it's a 5-member body, 3 or 4 of them all turn their heads to one member, like, we know you're ready to make the motion, so they make the motion. Then they all turn their heads to another member, like, okay, you're the one that's going to second it because we've talked about this. Then they all give their reasons, and there's almost no discussion. So it certainly happens, but you're right, Laura. It's almost it's sometimes overly obvious when it happens outside of the public forum, and it's embarrassing for the public body, and it's in violation of the act. Are there others who have questions?
Edie, go ahead.
You've talked about this very thoroughly, and I've been taking good notes. What happens to someone or some entity when there is a violation of the Freedom of Information Act? I mean, how does it get? I mean, we don't have to go into heavy here, but we've talked about all the things that we have to be aware of. But what happens if some group does violate it? How is it reported? What happens? Just a quick overview. You don't need to heavily deliberate.
Sure. So the Attorney General's office in the state of Delaware is one of its roles is adjudicating or reviewing complaints about violations of the Freedom of Information Act. So a complaint is made to the Attorney General. The Attorney General's office then asks the jurisdiction, in this case the City of Rehoboth Beach, whichever committee or board it is, to respond to the allegation. And there's a certain amount of time to do that, respond. And then the Attorney General's office will issue an opinion. Was there a violation or was there not a violation? If it finds that there was a violation, sometimes the office will attach certain conditions going forward. For example, the meeting was held illegally, therefore the public body should get back together in a properly noticed meeting to reconsider the action that was taken. There is an opportunity to go beyond a decision from the Attorney General's office and actually file a state court action in the Court of Chancery. And in that instance, the Act specifically provides for attorney's fees. So if a member of the public thinks that there's been a violation of FOIA, they file with the Court of Chancery, and Chancery Court finds that a violation did occur, that member of the public can have their attorney's fees paid by the jurisdiction. So, I mean, it is serious business. I mean, I don't know that I don't think the Act allows for jail time or anything like that, but it could result in attorney's fees. It could result in the action that was taken by the public body being voided. So there are ways for members of the public who think that FOIA has been violated to get relief through these different avenues. Did that answer it?
Yes. So it's a state violation and handled within the state according to whatever occurs.
That's right. Yeah.
Okay. Thank you. That's it.
Well, and so the other two things in my mind, it puts egg on our face to be exposed in the newspaper that we did something wrong, and also we have to pay the attorney to respond, not just once, but multiple responses to be able to clear up the issue. Right. In addition, of course, to the possibility of being found guilty and being requested to reconsider the action that was taken.
Right. I should mention, I guess, if you're on a board or committee and you're having questions about whether, something that's about to occur is proper under the Act or not, you've got me as a resource. But I will also say that Ann Womack, and if Ann's listening, I don't mean to, make her available to everybody, but she's had a fair amount of training on FOIA and open records and meetings, and she oftentimes is a very good resource to be able to field some of those questions pretty quickly as well. The mayor, I got to say, years ago, before the mayor was even elected commissioner, we'd have discussions after meetings about whether something was proper under FOIA or not. So he's been a student of FOIA for many, many years.
Any other questions from any of the commission and board members? If not, we'll move on to the next section. Glenn, thank you very much.
So let's talk a little bit about public records. And we talked about earlier how expansive the definition of a committee or a board or a commission is. Well, the same holds true for the definition of what is a public record under the Act. Now, remember, public records are records that the jurisdiction, the city in this case, needs to make available to the public should they ask for them. So public records are defined as information of any kind, owned, made, used, retained, received, produced, composed, drafted or otherwise compiled or collected by any public body relating in any way to public business or in any way of public interest or in any way related to public purposes, regardless of the physical form or characteristic by which such information is stored, recorded, or reproduced. So that's extremely expansive. And just to be clear, it includes the emails that you as a member send to a constituent or send to another member of the public body. That relates to public business. It also applies to text messages that you send. So in this day and age, if it's recorded or written or texted or videoed, you pretty much should consider it a public record that could become available to the public. So the exemptions regarding what is a public record are very narrow and are generally narrowly construed. Therefore, assume everything that is written, or I would say in today's day and age, written, videoed, recorded, or any other way stored, assume that it will end up on the front page of the newspaper or on a troublesome website. Everything at this point is pretty much available. So just be cautious about who you're sending messages to, texting, and whether it's appropriate under the Act, because or whether it's something that you would feel comfortable with the public seeing, because it is available under the Act. Now, the way that works is people can go to our website, and at this point, all public bodies are required to have public portals where you can go through the internet and request records. So what will happen is somebody will go on this portal and say, for example, I would like to have all the emails from the members of the Planning Commission for this 1 week long period relating to some application that's before it. And at that point, the city will do a search of its server for emails and documents that have certain keywords. We'll also send out a message to the members of the Planning Commission saying, here's the FOIA request that's been made. We need you to, recover any documents that you have and send them in to Anne. They'll typically go under legal review to see if anything's privileged or confidential that does not need to be produced under the Act. But again, it's very narrowly construed. So most all of those records will get produced to the person who's asked for them. So the general rule there is just be careful, because you need to assume that it's going to be available to the public and made public.
Thank you, Glenn. Now we've got Commissioner Gossett with his hand up.
Sure, Commissioner.
Yes, just a quick question. Is it accurate to say that state elected representatives in the House and the Senate are exempt from this rule?
There is a specific carve-out. It's an interesting question you asked. There's a specific carve-out for state representatives, state senators, state representatives, that their records are not subject to the Freedom of Information Act. And that's a discussion that we can have. I know that one member of the House has said in the past that it would chill a conversation between that member and their constituents if their emails, for example, were made public. And I sort of felt as though, well, if it would chill a conversation between you and your constituents, why wouldn't it chill a conversation between, a municipal elected official and that official's constituents? But at this point, you're exactly right, Commissioner. There is a carve out for state officials, but no similar carve out for any municipal officials.
So in essence, a double standard, but that's the way it is. Thank you.
Sure. Other questions?
I'd like to clarify again that very important that any of your personal emails on your personal email account can be requested via FOIA application, and you would need to give them up. So watch what you say.
Right.
Don't say anything derogatory about anybody. Call them up and say it right to their face.
Right.
But it might be worthwhile indicating to them how the advantage of perhaps creating a special personal email where it's easier to retrieve emails rather than going through their all personal.
Yeah, Anne can tell you that we've seen an uptick in FOIA requests over the years. I mean, she keeps good data on it, and it's risen remarkably over the years as to how many requests for public documents come in. So it makes it much easier for the member if, for example, you're using a computer for work emails, for your city emails, for personal emails. If there is a request that comes in and says, I'd like to see all the emails during a certain period of time on a certain topic, it's much easier for the member if they've kept all their public or all their city emails in a special folder or using a special email address. So they know that if they go to that location, they'll be able to find all the emails rather than weeding through all of your personal emails and all of your work emails to find what's relevant. So good point. Makes sense to try and catalog it in some way that makes it easier for you to find the records.
Thank you, Glenn. Bunky Markert.
Yeah, I just want to get maybe a further clarification on I guess more in terms of like a rule of thumb with regard to what constitutes public business. Invariably, I will be contacting our members to probably set up a time for a meeting and things like that, which I don't consider to be public. It's in preparation for a meeting or something like that, but we're not really discussing business and things. And I'm just wondering, under those circumstances, is it better to do that through Anne? I hate to be piling on Anne here, but is it just in terms of a procedure, like if I'm calling out to my members and saying, hey, we want to try to get a special meeting for such and such, and we need to converse just to figure out what the best meeting time is or something like that. Is there something that would be more recommended, I guess?
Well, so as a rule of thumb, you don't need to schedule a meeting to schedule a meeting. So it's okay if a quorum of you are trying to find a date that works for the group to get together and actually discuss and conduct public business. So that's the starting point. beyond that, I mean, it's rare that we would get a request for, those communications between a chairperson and their members as to the, setting a meeting date. But I suppose there could be a context in which those emails would be relevant. So they are public records in that you're setting a meeting of the public body. I just think that it would be rare that those records were actually requested. So I think, Bunky, as chairperson of the Parks and Shade Tree Commission, I think it's fine for you to have those sorts of communications with the members to set a meeting, and I don't see how that would create any violations of the act.
But also, there's no way to circumvent this. You can't, if you send something directly to your members, that's one thing. But sending to your members via Ann, it's still all FOIAble.
Correct. That's right.
Yeah.
That's right.
Thank you, Bunky.
Okay, thanks.
Go ahead, Glenn.
So, yep. So that's it on public records.
I do have.
Sure.
Go ahead.
Commissioner Bennett.
Thank you, Glenn. What's the direction as I prepare for the Board of Adjustment?
Well, we can't hear you.
Max, can you hear me?
You are.
Your audio shifted and we lost a lot of volume.
Let me
Lost you completely now.
Not now.
I can hear you.
That's better. Is this Commissioner Bennett?
No, this is Barry Brandt.
Barry Brandt.
Barry Brandt. Okay, go ahead. Just talk loud.
All right, quick question. As I prepare for the Board of Adjustment, I make personal notes, which I destroy immediately after the meeting. Is that public information? I know it's splitting hairs, but I write down notes in preparation as I look through material.
So there's
I hope it's not.
there's a split in some of the AG opinions as to personal notes. I've always said, assume that your personal notes are subject to FOIA. I just think it's safer to assume that some court eventually will say that they are subject to FOIA. But there is a split among the AG opinions on that topic, and there hasn't been a recent AG opinion that I'm aware of that has clarified whether those personal notes are or are not subject to FOIA. I think it's fine though for you to destroy them after the meeting. There's no requirement that you keep your personal notes for any period of time. I should say also that the jurisdiction as to what public records are available to the public, sometimes the public will come in and say, I would like to see a table of the Board of Adjustments decisions over the past 5 years and how many variances were approved and how many were not approved. Well, we don't keep that table within the city. So if you don't keep a record that's asked for, if the city physically doesn't have that record, there's no requirement that the city or any individual member of a public body create the record to respond to the public records request. Sometimes we'll get even, basically questions, and the act doesn't provide for this, it's not a clearinghouse for people to ask questions and have them answered. It's really only to request a document that is in the possession of the city.
Okay, thank you.
Thank you. Bunky, your hand is still up. I assume we've addressed you and it's just not taken down. Do you have anything further? Nope, there you go. Go ahead, Glenn.
Okay, so let's move in. We're almost an hour in. Let's move into ethics now and shift from the Freedom of Information Act if there's no other questions. So let's talk about the state code of conduct. As an appointed or an elected official within the city, you are subject to the state's code of conduct. Some jurisdictions, some municipalities have their own local code of conduct. The city does not, so we fall under the state's code. And those are basically the laws that regulate what you can and cannot do as an elected or appointed official. I'm not going to read all of this, but I will read this statement of policy. In our democratic form of government, the conduct of officers and employees of the state must hold the respect and confidence of the people. They must therefore avoid conduct which is in violation of their public trust or which creates a justifiable impression among the public that such trust is being violated. So it's all about conducting yourselves, and I mean, what did they say in the Boy Scouts, right? Don't lie, cheat, or steal, or tolerate those who do. And that's largely what the state code of conduct is. In fact, if you kind of follow that rule, you're probably going to, for most instances, be in compliance with the state code of conduct. But we saw just a moment ago in the Freedom of Information Act how the public is supposed to have access to its government and be able to observe them. Well, this is the flip side of it, where now not only are they supposed to have access, they're supposed to be able to trust that the public body is going to do things in a way that is appropriate, above board, and in a way that doesn't violate the public trust. Standards of conduct. So conflicts of interest. No state employee, state officer, or honorary state official may participate on behalf of the state in the review or disposition of any matter pending before the state in which the state employee, state officer, or honorary state official has a personal or private interest. So a personal or private interest. So typically you think about, is this somehow going to benefit somebody financially? That's a clear case of a personal or private interest. But the case law has expanded now to other areas where, for example, if you serve on a board of directors and that particular entity is now coming before the city in front of your public body that you serve on, well, now the cases say that you have a personal interest in that board upon which that entity upon which you serve on its board. So if you're serving in your role as an elected or appointed official and that entity is coming before you, it puts you in a difficult position because you have fiduciary duties to the entity upon which you serve in its board, and you have duties to the public body within the city. So that creates a private interest, and it is a personal interest, which is a conflict of interest. So it's not always just monetary interest that an elected or appointed official might have. So conflict issues get deeper and deeper. It says a personal or private interest in a matter is an interest which tends to impair a person's independence of judgment in the performance of the person's duties with respect to that matter. So if something is coming before the public body that you're serving on, and I would say you sort of just get a weird feeling in your stomach because something just doesn't feel exactly right, because you know some people who have an interest in what's coming before the public body, or you're related to somebody who has an interest in what's coming before the public body, or you personally could benefit. When those sort of red flags start to go up, that's the moment when you should step back and say, is it okay for me to participate? If it tends to impair your independence of judgment, that's when you have a conflict. The act goes on to say, or the code of conduct goes on to say, each state employee, state officer, and honorary state official shall endeavor to pursue a course of conduct which will not raise suspicion among the public that such state employee, state officer, or honorary state official is engaging in acts which are in violation of the public trust and which will not reflect unfavorably upon the state and its government. And that also goes down to the municipalities. So you don't want to do something that's going to reflect unfavorably on the city. So I get into these situations sometimes where people feel as though because they're appointed or elected, it's just our natural tendency. We feel like we were put on a public body to do a job, and it's important that we participate. It's important that we vote. We have something that we're going to contribute, and that's all true. But there comes a time when you have to be able to say, I have a lot to contribute to this. However, it will not look favorably on the city if I do participate, or you have to be able to say, I know this group that's going to benefit, and it's not going to look good if I do, or it's going to create a conflict. So it's just a matter of saying sometimes the issue is bigger than the individual participant on the body, and that participant on the public body needs to be able to say, I have a conflict. I'm going to step away. And stepping away, we're going to talk about recusal in a minute, but stepping away from participating in a certain matter doesn't mean you've done something wrong. I think sometimes people feel as though if they acknowledge they have a conflict and can't participate in a certain issue, that for some reason is an acknowledgement of wrongdoing. It's not. It's an acknowledgement of right doing. I can't participate in this because I have a conflict, so I'm going to do the right thing and step away. Let's move on to, here's some more examples of what are conflicts. Impairment of independence of judgment in the exercise of official duties, an undertaking to give preferential treatment to any person, the making of a governmental decision outside official channels, or any adverse effect on the confidence in the public in the integrity of government in the government of the state. So those are all examples of activities you as an elected or appointed official should not engage in. So let's go back to the question that was asked earlier about violations of the Freedom of Information Act. What happens if there's a violation of the Code of Conduct? And I don't have a slide on this, but I do want to address it. There is a commission within the state called the Public Integrity Commission. And they are the body that oversees allegations that an elected or appointed official has violated the state code of conduct. So what happens is somebody will file a complaint with the Public Integrity Commission. The Public Integrity Commission then will take up the issue. Oftentimes, these can get to the level of needing to hire attorneys, and there'll be witnesses that appear, and they can be pretty extensive and involved procedural matters. But at some point, the Public Integrity Commission will issue a decision saying that either the member did violate or did not violate the code of conduct. And, as an elected or appointed official, that can be, really damaging to your role and your future in city government. So obviously it's something that's to be avoided. The Public Integrity Commission, though, it also performs a role as an advisory body. So if an elected or appointed official wonders about a conflict issue and say that the appointed or elected official comes to me and we have a discussion about it, or consults with somebody else within the city, and we really can't get to the bottom of whether there's a conflict that would require the member to step away from or recuse themselves from taking action, you can file with the Public Integrity Commission what's called an advisory opinion. Basically, you say to the Public Integrity Commission, there's a meeting that's going to occur in about 3 weeks. Here's the issue that's on the agenda. I'm concerned about whether I can participate or not because I have this involvement in another area of my life, and I think it could create a conflict of interest for me. And they will issue a confidential and advisory opinion to you. And you can take their advice or not take their advice. Obviously, I recommend that you take their advice. But in some instances, it's a nice kind of backstop to have, in that it gives you assurances. For example, if they come back with an advisory opinion that says, no problem whatsoever, you can participate in this matter, then you have that in your hip pocket. And if you're accused of participating in something you shouldn't have participated in, you have that advisory opinion to be able to share with anybody who's making those allegations and say, I've already checked this out, I've got an advisory opinion, and I was okay to participate in this. On the other hand, if the advisory opinion comes back and says you should not participate, then you take that advice, you don't participate, and you go about your public business on the next issue. So that's how those claims get adjudicated, is through the Public Integrity Commission.
Commissioner Gossett has his hand up.
Yes, Glenn, is it solely up to the individual to determine if they feel they have a conflict of interest, or could that be shared by another member of the public body?
So as an elected or appointed official, it's always that member's decision as to whether they will recuse from a matter based upon a conflict or not. There's no provision within the city code for any of our bodies that says a quorum, for example, of the public body can force a member to recuse. It's always the individual member's decision. Now, it's perfectly fine for a member of the public body to question another member. I generally say don't do it publicly. Give them the courtesy of a phone call and saying this is coming up on our agenda in a few weeks. I think that you're involved in this matter and that could create a conflict for you. I think you should think about it. So that's perfectly fine. But the idea of being elected or appointed, you're elected and appointed. There's rights that come with that, and you get to vote on things, and nobody can tell you that you can't. But I will always caution people, if you vote on something that you had a conflict on, the entire issue can be invalidated. The courts have said that even if, for example, say for example, it's a 5-member body, say that one member has a conflict, the 5 vote unanimously to approve something. If even one member of the public body had a conflict, the courts have said that member's participation could have tainted the body so that members voted the way they should not have voted, and it'll invalidate the entire action. Did that answer you, Commissioner?
It does, but that action by the court would then have to be brought by a lawsuit and questioning the vote in that action?
That's right. That's right.
And then in your earlier slides, they refer to, as I read them, state officials or state honorary officials, and you said it trickles down to state and appointed officials, or rather elected officials. Is that somewhere in the language, or how is that addressed?
Yeah, the AG opinions have said that all of the political subdivisions of the state are subject to the code of conduct. So as a political subdivision, our municipality is subject to it.
So it's not called out specifically in the code, but that's the way it's been interpreted by courts?
I think that's right. I feel like I looked at this one time previously, and I couldn't find a specific reference to municipalities within the state of Delaware. But right, over and over, they've been adjudicated as subject to the code of conduct.
Thank you.
Thank you. And the courses I've taken through PIC articulate the same thing. Yeah.
Right.
Yep. Thank you very much. Go ahead, Glenn.
So this slide says, while the state code of conduct provides some guidance for financial or so-called actual conflicts, there's a large body of case law regarding constitutional-based conflicts of interest. So these are conflicts of interest that are outside of the 4 corners of the state code of conduct. There are instances where conflicts can be created that aren't specifically addressed in the code of conduct. So it says, even though a particular set of facts and circumstances may not suggest an actual conflict, the same facts and circumstances may nevertheless prohibit the affected individual's participation as a perceived conflict of interest. And I didn't intend today to get too deep into those circumstances. I'll just mention briefly that members of boards and commissions can perform their functions sometimes in a legislative capacity, where, for example, you're passing laws that are generally applicable to the entire city, or in a quasi-judicial capacity, where, for example, you're adjudicating certain rights of an individual like a judge would. The courts have said that when you're acting in a quasi-judicial capacity, even the perception of a conflict of interest will cause a need for a recusal. So it doesn't have to be an actual conflict of interest. If you're in a legislative capacity, simply making laws of general applicability, then there has to be an actual conflict of interest before a member would have to recuse. So there's a little bit of a distinction there. I don't want to get deep into it today, but just realize it's there. And if you have questions about it and want to know more about it, I'm happy to discuss it with you. And generally, if you're in a quasi-judicial capacity, you'll be reminded of it by me or somebody else, because there is a higher standard for those sorts of proceedings. Here's a reference to the Adjournment case. A public officer acting in a quasi-judicial capacity is disqualified to sit in a proceeding in which there is a controverted issue as to which he has publicly expressed a preconceived view, bias, or prejudice. Such officer must disqualify himself if he has prejudiced the case or has given a reasonable appearance of having prejudiced it. It is fundamental, and this is an important quote, it is fundamental that a quasi-judicial tribunal, like a court, must not only be fair, it must appear to be fair. So it's not enough for a member. So for example, I've been in instances before where, this is a perfect example. I like to call forum nights, where your candidates forum nights, I usually call them recusal nights, because inevitably some person who is running to become an elected official or on some other public body is going to be asked a question about a matter that's going to come before them after they're elected. So somebody says, well, don't you think that that particular project should be denied or should be approved? And you're at a candidates forum and you say, I think it's a great project. I think it absolutely should be approved. I couldn't imagine anything else going in that location. It's wonderful for the city. Then as an elected official, you're now asked on an appeal, for example, to decide whether the Planning Commission's decision to approve or deny something was appropriate, was made appropriately. Well, even if you can now sit down as in that quasi-judicial role and say, I feel completely unbiased, I know that I can do this in a neutral manner, listen to the evidence and make a decision that's the most appropriate, it doesn't matter because you've already made statements saying that you're for the project, and that could create the perception of an unfair tribunal. So even if in your heart of hearts you can be fair, as a quasi-judicial officer, you can't even create the perception of unfairness. And that gets a little bit deeper than I wanted to today, but if there's questions about it, I'm happy to answer them. So a perceived conflict is separate and distinct from the off-cited participation as a member of the public. Restated, even if an individual is permitted to participate in a particular process as a member of the public, he or she can still be disqualified from future processes due to a perceived conflict of interest. So for example, participating before, so oftentimes you'll see somebody appear before the Board of Commissioners and say, I am a member of this commissioner board, but I'm here participating as a member of the public. You just have to remember that even if you say it out loud that you're participating as a member of the public, if then that same matter becomes the board that you sit on, comes before the board that you sit on in a quasi-judicial way, you may have created a perception of a conflict of interest when you testified before the Board of Commissioners, and that would create a scenario where you'd have to recuse from participating in the action. So beyond the code of conduct, there's a couple slides here. Delaware law does not prohibit officials from participating in processes simply because the individual is a city official where there's no actual or perceived conflict of interest. So if something comes before the Board of Commissioners that will never in any instance come before the board or committee that you sit on, it's absolutely fine for you to come to the city commissioners meeting and say, I have a comment to make on, we were just talking earlier about refuse and pickup times and all of that. Well, the possibility that those issues are going to come before the Board of Adjustment is almost non-existent. So a member of the Board of Adjustment coming to the Board of Commissioners and saying, I want to comment on, what you're considering for garbage pickups and those sorts of things, no problem whatsoever. You can do that. It says, for example, there's no per se rule prohibiting a city commissioner from participating in a hearing before the Rehoboth Beach Planning Commission as a member of the public. And here's where it gets dicey. If the official in question takes a public position concerning the application and is later asked to decide the same application as a city commissioner, that official could be precluded from participating at the commissioner level due to a perceived conflict. So one of the members of the Board of Commissioners attends a planning commission meeting. That member of the Board of Commissioners says, I don't like this project. I don't think you should approve it. The Planning Commission then approves or denies the application, and it's appealed to the Board of Commissioners. That member of the Board of Commissioners who appeared before the Planning Commission now has probably created a perception of a conflict of interest, or maybe has an actual conflict of interest and cannot participate in the appeal before the Board of Commissioners. So recusal, we talked briefly about it. I can't emphasize enough, though, how I hope members don't feel like recusing is some acknowledgement of wrongdoing. It isn't. And remember that recusal, if a member chooses not to recuse and the decision of that public body is later challenged, if the member should have recused and didn't, it can invalidate the entire decision of the public body. So recusals are really important. On the other side, I always say don't over-recuse. You're appointed or elected to vote on matters. So If there isn't an actual or perceived conflict of interest, and it's not necessary that you recuse, I usually advise, don't succumb to some public pressure to recuse because somebody thinks you might have a conflict where you don't. You're elected or appointed for a reason. You're typically put on boards and commissions because you bring something special to that board or commission. So every time a member is unable to vote, something is lost on that board or commission. So to the extent there isn't a conflict, I say participate. Now, when you do recuse, you don't have to give an explanation as to why you're recusing. You can simply say, sometimes members feel the need to and would like to, and it's fine to do it if you do it in a way that isn't taking a position on the action. So for example, if you say this board is coming before us today, I'm on the board of directors, so therefore I'm recusing, that kind of an explanation is fine. It's not fine to say, I'm on this board that's coming before you. They're wonderful for 15 different reasons, and let me tell you about them. And this thing that they want you to do is a great thing, and I think you all should vote yes. Now I'm going to recuse. That's not a proper recusal because you've had an opportunity to influence the board. So no explanation is necessary, and sometimes the better or best practice is to give no explanation. I also advise that when you do recuse, it's best to leave the room. It's all about allowing the public body to have an open and free discussion about the matter. So if somebody who clearly has a conflict remains at the dais or is sitting in the audience, potentially making faces or giving a thumbs up or a thumbs down, that can influence the way the public body ultimately votes. So it's best to recuse and leave the room and come back in when the next issue comes up.
And the PIC does recommend that you leave the room, but let's talk about leaving the room in the virtual age.
Yes.
Can we just stop the video, the screen goes black, and turn off your audio also so we don't hear
Exactly.
Any grunts or groans about the topic that's in front of us?
Exactly. That's the best way to do it. I don't know that we've had to do it in Rehoboth Beach. Other jurisdictions I'm in have had to recuse, and they've done it exactly that way.
Yeah.
Turn off the video and mute.
Well, in this recusal, I think it's appropriate that you indicated we shouldn't look at it as a punishment. I know everybody wants to participate. It's very hard sometimes to walk out of the room and not participate because that's what you're appointed for or elected for. But 2 examples. Let me just. If you're on the board of the fire department, we don't have any members of the commission now on the fire department, but let's say we had somebody on the board of the fire department, then budget time comes around, they would need to leave the room when we start talking about the fire department and their request for funding,
Right.
correct?
Right.
And that's a type of recusal that likely would last all of one meeting. We have had a elected official, a commissioner before than that actually recused for the entirety of the Ocean Bay Mart situation, which is a couple dozen meetings there. But he had what he perceived as a conflict of interest, and so he stepped out at the very beginning. So that's very important to know. And I just want to reiterate what you indicate. Ethics violations are a big deal, right? Because they can cause us to rehear actions that we've taken before that could possibly come out differently with a different quorum of everything. Are there any questions for Glenn?
Yes, Nan Hunter, I have a question.
Yes, Nan, go ahead.
Sure, thanks. Going back, Glenn, to when you mentioned one of the slides said that the standards for conflict of interest, that there was a lot of case law based on constitutional questions. And I wasn't sure whether those were, what kinds of constitutional questions, or if you could give some examples of what that was about.
Sure. So oftentimes where we see it in municipalities are in the property right, which is a constitutional right. So that's why, for example, when you as appointed officials make decisions on land use matters, almost always there's a public hearing requirement, because it's a constitutional right, and people have due process rights and
Right.
need to be heard. So that's typically where it comes up. And that's, in those instances, typically you're sitting in a quasi-judicial role. So you're in that heightened standard where even a perception of a conflict would require a recusal.
Okay, so the constitutional issue is a procedural due process issue.
Correct.
And it pertains not just to conflicts of interest, but to all aspects of the procedure.
For sure. Yes, that's right.
Okay. Thank you.
So we're about an hour and 20 minutes in. I wanted to keep it high level, which I think we've done, but I'm happy to answer any questions. I don't have any other materials to share with you, but so I'm happy to answer any other questions.
Oh, is there any other attendees that have any questions? Either raise your hand or speak up. Identify yourself. Going. Gone. Hey, I thank you very much. We had almost 20 members today, and I'm very appreciative of you and your time. Also want to thank you for not just being here today, but serving on the commission or board. This is an awesome responsibility. You know, by way of appointment, you are a part of the city government, and we thank you. This presentation will be embedded in today's agenda. Actually, I think it already is, so you can look at it again. It will also be embedded into the portal. There's a special FOIA folder. And again, I'm going to request that other members that were not able to attend today are able to and request that they read this and look at it. If they need to ask any questions of Glenn, that's fine. I would say for the rest of the members that have viewed this presentation, that I haven't checked with Ann, but I'm going to suggest that your first question should be to Ann, because again, she is our FOIA coordinator, and she's cheaper than our attorney, and
better
save
too,
us a few
probably.
money. And then if she needs to, she'll forward your questions or queries to Glenn Mandalis. One last time, is there any further comments or questions? Seeing none, hearing none, I'm going to adjourn this meeting at 12:22 p.m. Thank you all very much for attending.